Okay, Sophie, now we're live.
Good morning. Welcome, everybody, to this second SCIFI webinar. I'm Sophie Stalla-Bourdillon. I am a professor in information technology law at the University of Southampton. And I'm also senior privacy counsel at Immuta, which is a software solution for smart and responsible data management that can be used in particular in data sharing environments. So the topic of today is the foundations of a risk-based approach to data protection. Why such a topic? Because if you understand the basics of a risk-based approach, you are then in a very good place to think about compliance and demonstrate compliance. So first and foremost, the first thing to acknowledge is that the GDPR is underpinned by a risk-based approach. And I've got some evidence, so I could cite several articles, and I would start with Article 24, which says essentially that taking into account the nature, scope, context, and purposes of processing, as well as the risks of varying likelihood and severity for the rights and freedoms of natural persons, the controller shall implement appropriate technical and organizational measures. The controller, the data controller, is the person in charge of complying with data protection principles and obligations. Is the person determining why the processing is happening and selecting the means for processing. And therefore, what Article 24 is essentially saying is that when the data controller selects the measures for compliance, it should do that considering the risks for my data subjects. In my recital 75, I've got an explanation as to what risks actually cover. And you are going to see, so this is very wordy, but what matters in the end is that the fact that ultimately they are related to physical, material, or non-material damage. So therefore, the definition is very broad. And ultimately, we are concerned about any significant economic or social disadvantage for my data subjects. Recital 76 adds something to this definition. It is saying essentially that the likelihood and severity of the risk to the rights and freedoms of my data subject should be determined by reference to the nature, scope, context, and purposes of the processing. And so what is important as well is that the evaluation should be done on the basis of an objective assessment, which is not always easy in practice, because some say the assessments in several instances tend to be more subjective than objective. And I could go on. I could also cite Article 25, Article 32, and Article 35. So for today, I have three questions that I'll try to tackle one after the other. The first one is why a risk-based approach? The second one, what does a risk-based approach really entail? And finally, how to conduct a risk-based approach when conducting data analytics projects, which should be very relevant in the context of smart cities. First question, why a risk-based approach? Two reasons for that. Because key data protection concepts are contextual, and therefore, I'm going to show you, indirectly risk-related. And second, because even non-personal data can present privacy risks. So it's important to conceive personal data as a spectrum. Yeah, the scope of data protection law applies to personal data. In theory, if you're not dealing with personal data, you're outside the scope. But I'm going to show you that it's a spectrum, and these categories are not clearly distinguished. So the very definition of personal data is contextual. What is the definition of personal data? And it's always useful to go back to the letter of the law that you find in Article 4. Personal data means any information relating to an identified or identifiable natural person. And it's important to see that there is the adjective identifiable, which means the definition is actually very broad. So to take an example, the value of a house, is this personal data? The answer, the legal answer is actually, it depends. It depends on the context and it depends on the purpose. So if I take my first picture, the value of the house is used to illustrate the level of real estate prices in a certain district. Here, in that context, I can make the argument that I'm not dealing with personal data. Second scenario, I'm changing the context, I'm changing the purpose. The value of a house is used to determine the extent of this person's obligation to pay some taxes. Now, I'm trying to learn something about an individual. I'm trying to evaluate the situation of an individual. I have a very strong claim that the data I'm dealing with is personal data. I can use a second example, the service register for a car. The service register contains information such as also information about the car, the mileage, the dates of service checks, technical problems, and potentially material condition. As such, these data relates to an object, yeah? But obviously, depending upon the way I'm going to use the data, I'm going to make this data personal data. So take my second picture, my second scenario, the service register is associated in the record with a plate number and an engine number. And ultimately, the purpose of the processing is to bill the customer. The whole thing becomes personal data. Third scenario, the purpose is slightly different. This time, I'm using this data in order to ascertain the employee productivity, so the person working within the garage. This, again, the same service register becomes personal data, but in that case, the personal data of my employee. So this is how the concept of personal data is actually very much contextual and ultimately depends upon your purpose. So I've said the definition of personal data is contextual. What is more, the definition of anonymized data is also contextual. And here you should be aware that anonymized data is outside the scope of data protection law. So in principle, if you are dealing with personal data, you are within the scope of the regulation, you are within the scope of EU data protection law, the whole thing applies. If you are dealing with anonymized data, in principle, you are outside the scope. But because the definition is contextual, you need to be careful. And so this is explained in my recital 26. Where it says in the green bit, the principles of data protection should therefore not apply to anonymous information. And you've got a start of a definition of what anonymous information is, namely information which does not relate to an identified or identifiable natural person, or to personal data rendered anonymous in such a manner that the data subject is not or no longer identifiable. And so the key question here is, how do I determine that an individual is identifiable? And you've got a test there in yellow to determine whether a natural person is identifiable. Account should be taken of all the means reasonably likely to be used. So this is essentially saying you can't simply look at the data. You need to go beyond the data and look at the context once again. And in passing, I'm just going to add one comment that is highlighted in purple. There is a distinction within the regulation between anonymized data and pseudonymized data. I'm going to show you. Pseudonymized data is also defined as data that has undergone pseudonymization, which could be attributed to a natural person by the use of additional information, should be considered to be information on an identifiable natural person. So if you are dealing with pseudonymized data, you are within the scope of the regulation. If you are dealing with anonymized data, you are outside the scope. To give you an example, let's assume I've got a researcher working with individuals, but ultimately producing the following information and the following observation, the following finding. One individual of a cohort of 5 in the study had a body mass index of over 16 and has also claimed special assistance benefit for over 5 years. The information, this particular information, the characterization of this information will depend upon who is holding it. And will depend whether that person is also holding additional information, which I call here the key information, which will allow you to actually go back to the individual once you've got this statement. So once the information comes into the possession of an organization that does not hold the key information, nor is likely to hold it, it ceases to be personal data. But if you've got the key, or you are in a position in which it's likely that you are going to get the key, it is personal data. And so if you are releasing this information and giving it away to somebody else, that somebody else might claim that this is not personal data, but you should understand that even if it's not personal data, there is still a low privacy risk, meaning there is still the possibility that someone could re-identify the individual if that someone gets access to the additional information or has prior knowledge. So in the end, not all hands are equal. And in particular, you need to distinguish between the situation of the data provider and the data recipient. So I've said earlier, key data protection concepts are contextual and indirectly risk-related. To say it in other words, characterizing personal data means expressly acknowledging potential privacy harm. And as I said, even non-personal data can present privacy risks, which essentially means non-personal data can easily become personal data. The moment you want to use the data to learn something about an individual, the moment the data becomes personal. So in the end, what is crucial to assess is the data environment. And I could say, in particular, if you're interested in sharing data, the data sharing environment. Is it open or is it closed? And if it's closed, what are the constraints imposed upon the stakeholders? And is it carefully monitored? Which means it's going to be quite difficult in the end to do open data without personal data. So now you know why a risk-based approach actually underlies the GDPR. But what does a risk-based approach actually entail in terms of assessment? A risk-based approach starts with data protection by design. That's my abbreviation here that you have on the screen, DPBD, data protection by design. Data protection by design, and I'm going to say more words about it, is very much the fil rouge of the GDPR. If you do data protection by design, you are in a very good place to demonstrate compliance. So essentially, to give you, once again, more words, as lawyers love words, this is the definition of data protection by design. So first, you need to take into account the state of the art, the cost of implementation, and the nature, once again, scope, context, and purposes of the processing, as well as the risks of varying likelihood and severity for your data subject. And then data protection by design means implementing appropriate technical and organizational measures which are designed to implement data protection principles, such as data minimization, and integrate the necessary safeguards into the processing in order to meet the requirements of the regulation and protect the rights of my data subject. And you should do that as early as possible, before the processing takes place. At the very least, at the moment you actually select the means of the processing. This is why this is called by design. But what is important to understand is that you need to select technical and organizational measures to implement your data protection principles, and then make sure your data subject can exercise their rights. So you've got two key sets of provisions that are actually intimately related to data protection by design. The data protection principles that are listed in Article 5, lawfulness, fairness, and transparency, purpose limitation, data minimization, accuracy, storage limitation, integrity and confidentiality, and finally, accountability, which is becoming more important with the GDPR. Bearing in mind that the GDPR is not all brand new, it's building upon an existing framework, which was the Data Protection Directive. So to do data protection by design, it's crucial to understand these key principles. Lawfulness, fairness, and transparency. You've got three requirements essentially in one. Lawfulness is asking you to identify a proper justification for the processing. Fairness is asking you to undertake a fair processing. And transparency, the processing needs to be transparent for the data subject, so they need to be informed. Purpose limitation is asking you to identify a specific purpose and a legitimate purpose and to stick to it. Data minimization is asking you to select adequate, relevant data that is going to be necessary for your purpose. So first you know your purpose and then you do data minimization. Accuracy is asking you to process accurate data. Storage limitation relates to data minimization in the sense that you need to be working within a time frame. You are going to process the data for no longer than is necessary for the purposes for which you are processing the data. Integrity and confidentiality relates to the security of the data, essentially. You want to make sure that the data is secure. And accountability, your data controller needs to be in a position to be able to demonstrate compliance. So he needs to know what's happening with the data, essentially. And then you've got the data subject rights, which are mentioned in Article 12, 12 to 22. So once again, when you are doing data protection by design, you are anticipating the way these rights are going to be exercised by your data subject. And you need to proceed in order. First, you need to think about the data protection principles because they are going to lay the foundations for the exercise of the rights. And then second, check that you have all the mechanisms in place to enable your data subject to exercise their rights. So the key provisions are the 7 data protection principles because they already implicitly refer to the rights. In particular, if I point to transparency, for example. And I've listed them on that slide. Once again, lawfulness, fairness, and transparency, purpose limitation, data minimization, accuracy, storage limitation, integrity and confidentiality, and accountability. So if you want to do data protection by design, how do you proceed? For each of these data protection principles, you identify controls, which means technical and organizational measures that are here to implement these principles. And so I have examples on that slide. If you take fairness, for example, you might want to make sure that you're using transparent pipelines with logs to know exactly what's happening with the data. Purpose limitation, you might want to use a mechanism to attach purpose to the processing activity. In other words, force users to acknowledge that they are working under a specific purpose when they are accessing the data. Data minimization, you've got a variety of techniques that you could be using. and that are actually covered under the method of pseudonymization or masking. You could hide columns, you could round some of the values, you can reduce the size of your data set, and you could use methods such as a differential privacy to inject noise within the data. Accuracy, you could implement mechanisms for cross-checking attributes. Storage limitation, here you need to make sure you're attaching data retention periods to processing activities. In other words, you need to be working within a time frame. Integrity and confidentiality, this is usually the most known. You use techniques such as encryption. And once again, the technique that you might be using for data minimization are also relevant here. So masking is also helpful for confidentiality, and the same for differential privacy. And I could also add access control. And finally, accountability, which is also related to transparency in some ways. Understanding what's happening with the data is crucial to be in a position to demonstrate compliance. Therefore, logging is a good example of a measure that you would like to take in order to implement that principle. It's important to note, though, that the GDPR does not prescribe an exhaustive list of controls. So you need to think of data protection principles as if they were goals. And there is not one way to meet these goals. Ultimately, the controls will be the result of a trade-off between utility and privacy. And that makes sense because to fully understand the potential for harm, you need to be looking at the context. So it's very much a balancing exercise in that sense. Not always straightforward, but it can be done. So let's take an example. Assume my purpose, for example, is to analyze patterns within data sets in order to improve a manufacturing process. It could be a car manufacturing process, for example. I'd have, or any type of other good, actually. So I could have a data set of that type, among others, with the following attributes: names, addresses, customer ideas, products, date of batches, date of customer claim, and default of product. And so let's pick one goal, the data minimization principle or the data minimization goal. How could I meet that goal? I've got at least two ways that I could use to actually meet the goal. The first one at the top would be to hide as many direct identifiers as possible and pseudonymize others, in particular the customer ID. Or if I am only interested in aggregates, and because I have the purpose that I identified earlier, this is likely to be the case, I could apply the technique of differential privacy and limit MAC queries to requesting aggregates. Or I could do both at the same time. So as I said, there is not one way to do it. Depending upon your use case, different solutions could be available. Crucially, the choice of the relevant control should be risk-based, and we go back here to our buzzword, risk. And so how do I do that? When I select my control, and now I have access control as a control, that selection should be linked to a specific threat. In that case, unwanted access. Threats, I call that also feared events, if I want to use the terminology of some of the supervisory authorities. I identify a threat or a feared event. I determine the likelihood of that event happening and then the impact of the event upon my data subject. Here, the concern is the potential harm for the data subject, which is not exactly saying that the concern is about the impact upon the organization. Yeah, that might be related, but first and foremost, we are concerned about the impact upon data subjects. And then, ideally, I quantify my risk level. So to do the risk assessment, I need to be using matrices, one for the threats and one for the potential impact, the harm. And usually what we see is that people are using 4 different levels. So now you know what a risk-based approach actually entails, and you know that you should be starting with data protection by design. You know that you've got your data protection principles, and that for each of the principles, you need to identify controls. You need to identify technical and organizational measures. That's all very nice, but how to conduct a risk-based approach when conducting data analytics projects? Why is it that I'm asking such a question? So ultimately, what if the goal is to promote data-driven innovation? Yeah? You've all heard about the words machine learning, neural networks, artificial intelligence. Neural networks, obviously, being the cutting-edge algorithms that are usually used to explain what artificial intelligence is. And as you know, they've got many nodes and many different layers. And as a result of that, the algorithm that sits between the input data and the output data is a black box. It's very difficult to explain. They are very useful, though, for pattern recognition, anomaly detection, and predictions, but they come also with drawbacks. And the assumption, the common assumption that is usually shared when you do machine learning is that you need a vast amount of input data for creating algorithms. And the reverse assumption is therefore that you can't do data protection by design that early. Because data protection by design, this is usually assumed, is actually antithetical to the way machine learning actually works. However, and I would like to insist, however, there is one way forward. And so you start to understand it if you break down the key stages of your model lifecycle. I could identify 3 stages at a high level. The first one, which consists of identifying, determining the objectives of the model, its assumptions, and its limitation. And it's also the stage at which you document, identify the data that you need for your objectives, assumptions. The second stage, which is about developing the model and testing the model. And the third stage, which is about deploying and ultimately using the model. And so let's go back to our data protection principles and let's try to reorganize them slightly. What you are going to see is that these data protection principles actually make sense for my 3 stages. How is this happening? Because they are, yes, constraining the way the stages are being conceived, but usefully, in a useful manner. So let's speak stage 1, which is about determining the objectives, the assumptions, identifying the limitations, understanding the data that you actually need for your objectives. Let's speak purpose limitation. Purpose limitation is a useful principle at that stage because it's helping you identify the objectives. Fairness is also useful because it's helping you for expressing the model assumptions and the limitations. And it's also useful because it's helping you assess the quality of the data, whether the data is biased or not. Accuracy is also helpful because, once again, that relates to the quality of the data. And ideally, you want quality data to build the model. Data minimization is also pertinent because you need relevant data to build the model. You might need sufficient data, but it's not saying that you need any data, you need relevant data. Lawfulness arguably is is a legal assessment. It's about finding the justifications for the processing, but as such, is not antithetical to data usage for algorithmic construction, building. Transparency is asking you to document all these choices, so it's not antithetical and is actually good practice. Storage limitation is constraining you to work within a time frame, which is also useful to understand whether you've in the end met your goals or not. Integrity and confidentiality is ensuring that you are dealing with data that is not altered, and ultimately accountability is requiring you to monitor and audit your documentation. That makes sense. And I could do the same for stage 2 and stage 3, because once again, these principles are relevant for stage 2 and stage 3. They are ensuring that your objectives stay the same over time, your fairness assessment stays the same over time, accuracy, the data remains accurate over time, transparency the same, that your pipelines remain transparent over time. Integrity and confidentiality is making sure that your data remains secure over time. And the same with data minimization, storage limitation, and accountability. Over time, you want to make sure that these principles make sense because they are useful for creating generalized and robust models. So that's done. This being said, so you can do it, but so data protection by design is compatible with data analytics. That is true, but, and you are going to tell me, there is a big but once again, data protection by design is resource intensive and requires expertise, and I would agree with that. This being said, data protection by design workflows can be made overly fastidious and complex. There is a light out of the tunnel, though. It's not all gloomy. And how do I make data protection by design work on the ground? The key is to make controls scalable. In particular, if what you want to do is a series of different data analytics projects. In other words, you need to make controls repeatable. So you remember my controls that I had for each of the data protection principles. The key question is therefore, how do we scale controls? And here I'm going to finish with 5 rules of thumb to explain you how you can scale controls for data analytics projects. The first one is that there are 2 types of controls, process and system controls. As they are complementary, you should look for both. What do I mean by process and system controls? Process controls essentially are there to identify who should do what. In other words, who has the expertise to decide on that specific matter. And system controls are there to self-execute the decisions, to make sure actions follow decisions. Second rule of thumb, depending upon timing, controls can be preventive, detective, or corrective. Bear in mind that preventive controls are the most effective, so make sure you get some of them in your list. I give you an example. Assume my model assumption is that the model can be built with aggregates only. Therefore, my preventive system control is that access to training data is only made possible through a differentially deprived method. And another thing to bear in mind at this stage is that do not assume that in most cases, working with aggregates only will not work. What I'm being told by data scientists is that this is often discarded because this is seen as too complicated, but that's often a misleading assumption. Third rule of thumb, look for control commonalities and get rid of anti-patterns. Here, standardizing data access is the first step to look for control commonalities. Ideally, you want one control that works for most of your projects' use cases. An example is very likely that to build models, direct identifiers will not be needed. So you want to hide them or mask them. So masking is a key control, meaning a repeatable, scalable control. So to get rid of anti-patterns, you need to start with a default control that negates utility. Give you an example. You hash all your personal data, you mask all your personal data. And then you need to remember the tightrope. You need to balance privacy and utility for specific projects and go for more utility when this is justified in context, when you've done a further assessment. Fourth rule of thumb, you classify your projects according to risk, because once again, now you should know that by heart now, risk is at the foundation of the approach that is underpinning the GDPR. Understanding your purposes is very useful to do this ranking. The higher the risk, the more stringent the controls. Fifth rule of thumb, you make your governance personal control experts, which is not saying that they should become control freaks. Why is the case? Because everyone has a role to play. And as you know, with roles come responsibilities. In fact, but if you look at the practice, best practice should lead to dividing your teams into 3 lines of defense. And so if I'm thinking about data-driven businesses, I could have the following 3 lines of defense. The first line involves governance personnel, so compliance teams, lawyers in most cases, businesses, and data scientists. And so I've got guidance that is produced by my governance personnel. Then my businesses sets the objectives. My data scientists identify model assumptions and limitations, which are then acknowledged by my businesses. Time 2, for my second line of defense, I'm going to use data scientists, once again, to validate assumptions and limitations, and governance personnel to validate the risk assessment and set the controls. And at stage 3, for my third line of defense, I'm going to use other data scientists to audit and other governance personnel, once again, to audit that this is done according to guidance. If now I'm thinking about data-driven community initiatives, smart city, I could follow the same structure, although I might not use exactly the same words. So in my first line, I could have a governance board that would produce the guidance, then a steering committee that is responsible for setting the objectives. I still need my data scientists to identify model assumptions and limitations, but then also need an acknowledgement of these limitations by the body responsible for setting the objectives. I've got a second line of defense, which comprise several disciplines, the data scientists who need to validate assumptions and limitations, and once again, governance personnel, governance board who needs to validate the risk assessment and set the controls. And the third line should also comprise a variety of expertise. Data scientists, technical guys need to audit what's happening, but also the governance personnel needs to make sure compliance has been followed. So it's very much a teamwork. And the good news is that some controls should always be there and can be dealt with only once. In particular, if you are using an architecture to facilitate access to data in order to standardize data access. So conclusion. EU data protection law is underpinned by a risk-based approach. Conducting a risk-based approach starts with data protection by design. And you should know what data protection by design actually means now. It requires selecting controls for each data protection principles as early as possible. Fourth, data protection by design is compatible with data analytics and should lead to good practice, even though it is resource intensive, it requires expertise. And finally, to make data protection by design work for open innovation, it is crucial to scale controls, for example, by using an architecture that will standardize data access and enable different types of controls, preventive, detective, and corrective controls. So it's possible to drive innovation with data protection by design once controls are scaled. That's it for today. If you want to know more about data protection by design, we've developed a white paper with Immuta. And if you still want to read further, you could also read a very recent article written on the topic on data analytics and data protection by design. Can we have both? And it will not surprise you that the answer is yes. Thank you for your time. And if you have questions, I'm very happy to take them now.
Thank you, Sophie. This is Judith from Bournemouth. We don't have any questions so far, so if people might have questions after the webinar, they can always or contact you or contact SCIFI, and we will make sure that their questions will be answered. The next webinar. SCIFI webinar will be within 2 weeks, the 14th of May, and that will be on best practices of creating city dashboards. So I thank you all, and hope to see you soon during our next webinar.
Thank you.